Hello, everyone. Welcome to Court with Krissy. This defendant, she had one job: serve legal documents. The judge, he also has one job: she's serving 6 months in jail. Or is she? This sentencing, it goes south, but she'll be back. I hope you like it. Court with Krissy is now in session.
We can go back on the record, and Mr. Krissy, we can call your case.
Thank you, Your Honor.
People be Brittany Abbott, file 25-7088F8. Counsel, you want to state your appearance, please?
Mr. Goodrich, Wayne County Prosecutor.
Luke Krissy, on behalf of Ms. Abbott, Your Honor.
Right, and I'm here for sentencing on a charge of evidence tampering. It's a 4-year statutory maximum and a guideline range at 0 to 9 months. Mr. Krissy, have you had a chance to review the pre-sentence report and recommendations with your client?
Your Honor, I have no additions or corrections to that report.
Okay, and any scoring challenges?
We did not have.
Ms. Goodrich, any additions, corrections, or scoring challenges from the people?
No, Your Honor.
All right, Mr. Krissy, anything you want to say on your client's behalf?
Well, Your Honor, I'd just say that I believe Ms. Abbott's going to be successful on the term of delay, and the agreement that we've worked out with the prosecutor just really felt like a interesting case to me, in that she gets hired on, or is hired on by some firms that are collecting credit card debts, and she's to serve people. And there's not really much training as to how that service is to be done. I think she now understands the ramifications of what had happened. She has expressed to me she's very apologetic to the victims in this case, and sorry that if anything happened with their case, that she's sorry about that. But you know, she did. It wasn't that she just mailed it in, Your Honor, where she said she served somebody, but she didn't. She did drive down from Marquette, go to these residents. Although somebody's at the residence that she serves, it's not the right person. So again, I think the disposition that's been worked out here is addresses the issues and addresses the conduct and behavior. I would ask the court to follow the agreement that we have for this 6-month delay with Ms. Abbott at this time. Thank you.
Well, I mean, I wonder about those facts. She filed a proof of service with the court indicating that she had personally served the named people at an address and the location, and included a description of the person, including, it said for one of them, described his appearance, including having a missing ear. So that sure sounds like Miss Abbott is intentionally trying to say, yes, I personally served this named person, when she didn't, and not just some sort of technical mistake that she didn't know she could leave it with someone else at the household. So help me square that circle.
Well, Your Honor, there's an application with these firms that she's working with where you just check the box when the paper's delivered. They do the proof of service to the court, and that's the proof of service that was provided to the court. She was not personally taking those to the court. Again, she accepts her responsibility for the improper service. We're definitely not making any excuses there. It just, Your Honor,
But the proof of service is signed by her, right?
it would be electronically on her phone through the application with the company that she has. And so again, as I've stated, you know, she's learned from this. She understands leaving it with anybody at the house was not proper, but you know, it could have been where you just check the app that you did it, and you didn't even leave your home or come down to try to affect services. And she's accepted the responsibility by entering into this delay, that she knows that it was not proper, and we're not making any excuses here, Your Honor.
Well, it sounds like you're saying she's not technically guilty of intentionally tampering with evidence.
Not at all, Your Honor. I would not do that.
I mean, just making a mistake about what the court rule requires is a different thing entirely from felony tampering with evidence.
Well, and then I think the court is not hearing or is misunderstanding. I'm just trying to explain the circumstances or the facts around that, but I'm not making any excuses, Your Honor. I think it's important for the court to know the totality of those circumstances. That's all. Again, we've accepted the responsibility. We've, you know, got her meeting with probation in days. She's come down from Marquette. We're totally going to comply with the delay period.
Well, I'm wondering whether she should get a delay, honestly. So I'm wondering a process server that intentionally falsifies a proof of service with a court. That's what she's convicted of.
Yeah.
Somebody that does that, in my mind, ought to go to jail. So that's what I'm thinking about.
Your Honor, I don't believe this is the case that would warrant that. I definitely understand the court's concern. I do. But I'm not trying to make any excuse for the client. No.
All right, I can tell you there's no way I'm doing a delay. All right, Ms. Abbott, you don't have to make a statement today. Is there anything you want to say or no?
Yes, I would like to sincerely apologize for being completely negligent.
See, okay,
naive.
okay, hang on.
Yes, sir.
You're not convicted of being negligent. Now, you pled no contest, so I can't force you to make a statement about this. But I'm not going to sit here and let you. You're convicted of intentionally tampering with evidence. You're not convicted of negligence. So let's start again.
I was incredibly naive and I did not understand how to do my job at all. I didn't understand how to be a process. So I just want to say something.
All right, Ms. Goodrich, any recommendations from the people?
Yes, Sharon, thank you. Here as stated, two victims had come forward on June 4th of 2025 to report perjury complaints stating that there was proof of service filed with the district court where they were not served. Fortunately, they both were able to prove that they were at work at the time. What's confusing about the explanation here today is that the explanation that the defendant has given is that she handed it to someone else, but that's not in the PSI description of the offense. And in fact, it says that neither of the people had cameras at their house to see if a process server was at their residence. So it'd be strange that nobody at their house would tell them, hey, I got this paperwork here today if somebody else was actually served. So I would guess that no person was served at either household based on those set of facts. The defendant is 36 years old. She has no prior felonies and one prior misdemeanor. Looks like she's part-time or sporadically employed and has a bachelor's degree. The guidelines are 0 to 9. The plea agreement was for the 6-month delay. The PSI accepts that with a focus on services being for mental health treatment for the defendant, as well as using her positive family support system more so that she makes better decisions in the future.
All right, thank you. Ms. Abbott, if you please stand for a short sentence. All right, Ms. Abbott, I don't buy a thing you're selling me today. You know, if what you're saying is true, at the end of what I'm going to tell you, you should withdraw your plea and go to trial and get acquitted. Because if what you're telling me is true, I don't know that that's a crime. Making a mistake at your job is not a crime. I probably did it today already. You're convicted for certifying as a process server, certifying that someone was served personally when they weren't, and submitting something false to a court. That's a very serious crime. It's a terrible breach of trust. It undermines the legal system to the harm of litigants. You wouldn't like it today if I sentenced you and you weren't even here and didn't know about the case, because you're entitled to due process of law. The bare minimum of due process of law is notice and an opportunity to be heard. By your lies to a court, you deprived one of your fellow citizens of notice and an opportunity to be heard. I think that's a pretty crummy thing. You have no prior felonies, one prior misdemeanor. I don't really see a need for services on probation. It's really nothing that connects to this behavior of any like criminogenic needs, you know, that would have contributed to this situation. I certainly don't think that that kind of behavior warrants 6 months of a delayed sentence and a dismissal at the end. So again, either you're innocent and should go to trial, or if you're guilty, this would not be a just outcome. So it'd be my intention today to sentence you as follows. $68 in state cost, the crime victims assessment of $130, court costs of $350, comply with DNA testing and pay a $60 fee, and serve 6 months in the Sheboygan County Jail with credit for 1 day previously served. That does not comply with that is within the advisory guidelines. I think even though it's an intermediate sanction, the circumstances of this crime, the breach of trust and the interference with the administration of justice are inadequately taken into account in the guidelines. So therefore, that does not comply with the sentence agreement. So you've got a choice to make, and I'll give you a minute to talk with your lawyer about that. You can either accept my sentence as I've announced it today, or you can withdraw your plea, and it goes back to a pretrial posture, and we'll schedule the jury trial on 2 counts of obstruction of justice and 2 counts of evidence tampering. So I'll give you some time to talk with him. And well, yeah, if you'd like, I can pass the case, and I would just direct you to tell Ms. Abbott she may not leave the 2nd floor of this courtroom and of this courthouse until we address the matter.
Yeah.
Yeah, but you can go out in the hallway and talk.
There you
Pass the case. All right, Mr. Krissy, we can recall Ms. Abbott's case.
Thank you, Your Honor.
All right, and I had announced a sentence beyond the terms of a sentence agreement and given her some time to talk with you about her options. Do you know how she wishes to proceed?
Yeah, we would like to withdraw our plea at this time.
Okay, Ms. Abbott, your plea will be withdrawn, bond will be continued, and we'll schedule this for a docket call for, and we'll have that docket call be a plea and motion cutoff, and we'll pick a firm trial date at that time. So let's, I mean, we could come back, I've got a docket next week on the 9th. We could just, gives you guys a couple of, a few days to see if there's anything else that you want to do, given what I've said here today, or if you want to schedule it for trial, and then on the 9th, we can do that. And Ms. Abbott can appear by Zoom for that, and you can too. That's no problem. You available next Tuesday?
I'm not sure. I don't have a phone. My phone's operating right now. So
Okay, well, let's schedule this for next Tuesday, June 9th.
that's a problem. I can let the court or prosecutor know.
Yeah, but don't wait for the mail. It's just next week. So
I understand, Your Honor.
I know the mail won't get to you. So next Tuesday, July 9th at 1:30, Miss Abbott, you can appear by video as you have previously. And we'll, at that date, schedule it for a trial if we need to.
Thank you.
All right, thank you, Mr. All right, and Mr. Flippa, we can recall People v. Sam Hill.